The question is that this bill be now read a second time. I call the member for Heffron.
Mr Deputy Speaker, I make a contribution to the debate on the Courts and Crimes Legislation Amendments Bill 2015, and in saying what I propose to say, I endorse and I adopt the views, reasoning and participation in the debate of the Shadow Attorney-General and Member for Liverpool, and nothing I say should either directly or by implication to be seen to be inconsistent with the view expressed by the Shadow Attorney-General. The Shadow Attorney-General has brought to my attention a letter that he received from Jane Needham of Senior Counsel, the President of the New South Wales Bar Association, dated the 6th of May 2015, expressing the Bar Association's concern about some provisions, particularly in Schedule 3 of the bill, that had not been brought to the Shadow Attorney-General's attention prior to his contribution and to his second reading speech. Accordingly, he had brought it to my attention, and I wish to bring it to the attention of the House. And I particularly want to just refer to a paragraph at the end of Ms Needham's letter because it indicates a matter of considerable substance. Ms Needham says, in relation to the possibility of the introduction of a system of which this legislation would permit, says this, and I quote, "It would substantially undermine the concept of an independent judiciary. The Association would find such a fundamental and undesirable alteration to this state's constitutional fabric unacceptable." They are quite strong and powerful words to be used by the Bar of New South Wales in respect of the wording of a bill of which is being put through the House with a whole heap of other particular provisions with an assumption that they are just fixing up specific provisions and necessarily don't involve multiple changes to public policy. And that's certainly what was the view of many participants in this debate, and certainly may well have been mine. It is that clause expressed by the Bar Association that must cause this House to just consider whether or not those provisions in Schedule 3 of the bill should actually remain there, or whether they interfere. I'll come to it in a moment. Whether or not they do have the potential to obstruct fundamental principles, particularly infringing the principle of the doctrine of separation of powers. Now, every participant in the debate knows that the bill proposes amendments to the Supreme Court Act, the Industrial Relations Act, the Land and Environment Court Act, the District Court Act and Local Court Act to enable judicial officers to be appointed to the age of 77 years rather than 75 years. That really doesn't pose, I don't think, a particular problem. The Commonwealth Constitution, many of us will recall, were amended to require the retirement of High Court judges at the age of 70. I venture to say when the Whitlam government proposed those sort of constitutional amendments, 70 was seen to be almost in one's senile years in those days. But now, of course, with age discrimination applying, and there were in the old days problems of trying to get judges to retire, and the US Supreme Court had the same problem once they reached ages where they should no longer be there, and the doctrine of the doctrine of separation of powers prevented anybody from doing anything about it really. Because there's also another obligation, and that is to, of course, protect the reputation of the judiciary, which is another one of the fundamental functions of both this House and also the executive government. So there's no particular problem with that provision. The problem occurs in relation to the appointment of acting judges for periods as long as 5 years. Now, the Bar Association and probably most of us would be opposed to acting appointments because they risk the infringement of the doctrine of separation of powers. it's no doubt done for financial reasons to clear the backlog of court lists to enable matters to proceed. And what's been happening in recent years is generally judges who reach retirement age are then appointed acting judges, and those appointments are renewed on a yearly basis. It doesn't cause any practical problem because, firstly, those judges, acting judges, are well remunerated. Secondly, they are very experienced judges, so the ones that shouldn't be given acting judges usually aren't. Sometimes those at the bar are terrified when the judge retires he might come back again, but generally the selection of acting judges has been exemplary. And they already have their judicial pension, and so that there is nothing to gain or lose by their participation in a temporary appointment. So it's not ideal. But what happens is that if you can then adopt almost similar to a recorder system of the United Kingdom, where you start plucking members of the bar for acting appointments midway through their careers for periods of 5 years, as they are facing renewal again, there is a real concern that there is that by the Bar Association that interferes with the doctrine, and there is a risk it can interfere with the doctrine. Now, I was fearful when this government, or no, it was actually the Labor government, amended the Crown Prosecutors Act and Public Defenders Act for those reasons. I mean, I can remember times at the bar when I was cross-examining senior Labor ministers in a particular trial and putting propositions to them, and I thought, just as well I've got appointment of tenure, because the Labor government probably wouldn't after this trial reappoint me if I was coming up for a particular period of time. But so I didn't think that had much substance. But when it comes to the judiciary, and again with great respect to local court magistrates, we're not talking about a magistrate. We're actually talking about Supreme Court judges and judges of the Court of Appeal or judges of Supreme Court status. And so it is not appropriate. It is just not appropriate to appoint, say, a practitioner for 5 years to a Supreme Court judge and say, well, you're not reappointed, because you might have been on the Court of Appeal and you might have overturned amendments to the Independent Commission Against Corruption Act that the government desperately wanted you to do for whatever purpose. So there is a substantial risk, and the Bar Association has it in a far more complex and better way expressed those concerns. They say this. I do, however, wish to raise a note of caution. The Association would be strongly opposed to any proposed system that involves the appointment of current legal practitioners to fixed-term, part-time acting judicial commissions. The issue is one of principle. Such appointments would have the potential to tarnish the reputation of the courts and create at least the perception of conflicts of interest in certain cases. Now, that's their statement of principle, but they refer to examples in the 1990s when they say when this practice was adopted in New South Wales in the 1990s, there were cases when part-time acting judges had before them clients who provided substantial amounts of work to them when they were not sitting as an acting judicial officer. A litigant in such a case could reasonably query whether or not he or she had a fair hearing in those circumstances. There were also instances where acting judges were part heard as barristers before the same acting judges. Without wishing to impugn the integrity of those practitioners who were appointed as part-time acting judges at that time, there was a popularly held perception in some quarters that such acting judges might fashion judgments in such a way that might ensure their reappointment at the expiry of their term. Mr. Deputy Speaker, might have an extension of time.
Yeah.
The question is that the member for Heffron's time be extended. All of that opinion say aye.
Aye.
To the contrary, no. I think the ayes have it. Continue on. The member for Heffron.
says this: the potential to undermine the integrity of the court system and create potential and actual conflicts of interest is very real. It was for this reason that the then government abandoned the practice of appointing legal practitioners as part-time acting officers at the turn of the century. There was an instance that I can inform the House, I won't disclose who, of a member of the bar who was an acting judge, and was given to the district court and was given the responsibility of determining victims' compensation, and it was indicated to her that she was required to do so many per day. She found the task impossible. She was a member of the bar and is a senior member of the bar now of some ability. It must be because she's now silk. And after her 12 months, she was not reappointed. A judicial officer should be able to complete their task in a thorough way to the best of their ability without having reappointment held over her head, and that was not by the executive government. The other issue that I'm quite concerned about is the appointments of these acting judges to be done by the Attorney General rather than by the Governor. Now, whilst we all know as a matter of practice the Attorney General appoints the judges, but in effect it's got to go via Executive Council, and there's a check mechanism really in place. There is usually a formal consultation process with the Bar and the Law Society. There is a formal consultation process, or at least a cabinet consultation process between other ministers of the Crown, and so that the Attorney General, who individually can prosecute all these individual offenders, provides some theoretical removal from the actual appointments. What I would ask in respect of this bill is that those matters raised by the Bar Association that I raise on their behalf, and that I raise on my own behalf and on behalf of the Shadow Attorney General, they are not meant for any other reason other than to bring to the attention of the House and to the government the seriousness of the consequences of these provisions which are a part of the bill. And what I ask is that the Attorney General rethink, because sometimes these things can slip through, particularly in ones where there's a whole heap of amendments to a whole heap of bills. Just think that maybe the Bar Association is right. I think they probably are. And to just go back and engage with consultation with the Bar Association before this bill completes its passage in the other place. Because, as I indicated to the House when I started, the second last paragraph of the letter from Ms Needham of Senior Counsel says, when she refers to the ability to reinstate what used to exist in the 90s, that it would substantially undermine the concept of an independent judiciary. The Association would find such a fundamental and undesirable alteration of this state's constitutional fabric unacceptable. Nobody in this House, nobody, not one member of this House would agree to in any way do anything that would risk undermining the alteration of the constitutional fabric of this state. And so I do ask the Attorney just not to allow departmental officials to flush it through because it's convenient, but to examine it carefully between now and the passage in the other place, and engage in genuine consultation with the Bar Association and Law Society just to make sure there's no error in these provisions.